The second issue is whether the matters raised in the consolidated petitions are justiciable. Ordinarily, an application for conservatory orders concerning the subject matter of a suit is relatively straightforward, as the law in this area is well established. However, the current applications before the court are far from routine. These applications are imbued with political maneuvering between the applicants and the respondents. In essence, power struggles involving other constitutional organs have been brought before this court for a legal solution. As a result, this court has become the stage upon which political excesses are to be examined and resolved. Inevitably, such cases evoke intense emotions. The impeachment case of the first petitioner currently before this court exemplifies the dilemma faced by the judiciary when handling cases that straddle the line between legal and political domains. There is no doubt that many are watching to see how the court will navigate this delicate issue, one that has significant implications for the doctrine of separation of powers among the three arms of government. Answering this issue requires a brief analysis of the doctrine of separation of powers in relation to the doctrine of justiciability. French political philosopher Montesquieu first formulated the doctrine of separation of powers through his seminal work, L'Esprit de Louis, in other words called the Spirit of Laws, which was published in 1748. Montesquieu argued that such separation limits the possibility of arbitrary excesses by the government, since the sanction of all three branches is required for the making, executing, and administering of laws. The Constitution of Kenya 2010 clearly delineates the three arms of government, each with its own distinct personnel and roles, as set out under chapters 8, 9, and 10. Chapter 8 establishes the legislature and details its composition, functions, and powers as the law-making body of the government. Chapter 9 outlines the structure, the functions of the executive, whose primary role is implementing and enforcing laws and policies. Chapter 10 focuses on the judiciary. It defines the structure of the courts and lays out the judiciary's mandate as the arbiter of disputes and the guardian of the Constitution, tasked with interpreting and applying the law impartially. While the provisions regarding judicial power under Chapter 10 of the Constitution are clearly defined, the political question doctrine, also referred to as the non-justiciability doctrine, highlights the limitations on the judiciary's role in adjudicating matters that fall within the purview of other branches of government. This doctrine essentially asserts that certain issues are not suitable for judicial determination because they are better addressed by the legislative or executive branches, which have the constitutional mandate and expertise to handle them. Black's Law Dictionary, 10th edition, at page 943 to page 944, defines justiciability as a matter that is, in quote, proper to be examined in courts of justice, or a question as may properly come before a tribunal for decision, close quote. There is an abundance of judicial pronouncements expounding on the doctrine of the political question. For instance, in Marbury versus Madison, Chief Justice John Marshall established the principle that while the courts have the authority to interpret the law, certain political questions are outside the scope of judicial review. The case underscored that where the Constitution assigns duties to other branches of government and does not provide standards for the judiciary to assess those duties, the matter is deemed as non-justiciable. Closer home, in William Odhiambo Ramogi and two others, as Attorney General, a 5-judge bench observed as follows: The justiciability doctrine is rooted in both constitutional and prudential considerations and evinces respect for the separation of powers, including a properly limited role of the courts in a democratic society. One justiciability concept is the political question doctrine, according to which courts should not adjudicate certain controversies because their resolution is more proper within the political branches. In Baker versus Carr, the United States Supreme Court outlined 6 matters that could present political questions as follows. 1, a textually demonstrable constitutional commitment of the issue to a coordinate political department. Or 2, a lack of judicially discoverable and manageable standards for resolving it. And 3, the impossibility of deciding without an initial policy determination of a kind clearly for non-judicial discretion. 4, the impossibility of a court's understanding undertaking independent resolution without expressing lack of the respect due to coordinate branches of government. And finally, an unusual need for questioning adherence to a political decision already made and the potentially of embarrassment from multifarious pronouncements by various departments on one issue. Additionally, the Court of Appeal in Kenya Airports Authority versus Mitubel had this to say: with this in mind, the role of the legislature is to make laws and policy, and that of the executive is to implement those laws and policies. The role of the judiciary is to interpret the policies and laws as enacted and approved by the legislature and the executive. Generally, courts have no role to play in policy formulations. Formulation of government policy is a function best suited for the executive and legislature, close quote. In Kiriro versus Ngugi, a 3-judge bench had this to say: a court must satisfy itself that the case before it is not caught up by the bar of non-justiciability. The concept of non-justiciability is comprised of 3 doctrines. Firstly, the political question doctrine. Secondly, the constitutional avoidance doctrine. And thirdly, the ripeness doctrine. The doctrines are cross-cutting and closely intertwined. We shall, however, endeavor to, as far as possible, delimit the operation of each doctrine in isolation. Close quote. This bench is tasked with determining whether the issue of the impeachment of the deputy president falls within the category of cases where the concept of non-justiciability would prevent this court from hearing and deciding the matter. The essence of this question lies in assessing whether the political question doctrine would apply, thereby barring the court from intervening in what might be considered a matter reserved for legislative or executive branches under the Constitution. Learned counsel Dr. Fiancolu relied on the U.S. decision in Nixon versus United States to argue the case that the dispute before the court is a political question and hence non-justiciable. We have given due consideration to this decision, noting that it pertained to a dispute involving the impeachment of a Chief Justice of a federal district court in the United States. In resolving the matter, the district court held that it lacked jurisdiction to hear an appeal from the Senate regarding the impeachment of the chief judge, deeming the claim non-justiciable. In determining whether a dispute is non-justiciable, the court held that the test depends on whether, in quote, there is a textually demonstrable constitutional commitment of the issue to a coordinate political department or a lack of judicially discoverable and manageable standards for resolving it. The question to ask, in simple terms, is whether the 2010 Constitution specifically assigns the sole responsibility for resolving disputes arising from the impeachment of the deputy president, as in our case, to another branch of government. Additionally, Are there clear legal rules or standards that a court can apply to reach a fair and just decision on such matters? Within the context of the American system, and as articulated by the court, the learned judges answered the first question in the affirmative. They held that Article 1, Section 3, Clause 6 of the U.S. Constitution demonstrates a clear textual commitment of the impeachment process to the Senate. For clarity, this clause, known as the impeachment trial clause, states in quote, "The Senate shall have the sole power to try all impeachments," close quote. We previously referenced the pre-2010 Constitution drafts that were brought to our attention by Dr. Tiankolu. What is evident from this text is that the people of Kenya clearly intended for the impeachment process to be a justiciable matter. This conclusion is supported by the fact that each constitutional draft contained provisions affirming this intent. This position is unsurprising when considering the historical context in which the Constitution was created. The people of Kenya sought to move beyond a past where the judiciary was often marginalized or bypassed in efforts to check governmental excesses. Instead, they envisioned a new constitutional order in which all branches of government would be held accountable and subject to comprehensive constitutional oversight. This aspiration was central to establishing a balanced system that ensured no arm of government operated beyond scrutiny. We are therefore not convinced, against a holistic reading of our Constitution, that there was any intention to deliberately place the impeachment power on the legislature with no judicial involvement. To hold otherwise would be to create an absurdity whereby the dictates of the Constitution under Articles 23, 160, and 165, 3D2 would be defeated. In our view, this decision is further distinguishable by the fact that the appointment of judges in the United States and Kenya differs significantly due to unique political structures and systems of government. Judicial appointments in the U.S. are more overtly political, with the President and Senate playing direct roles. In contrast, Kenya's system emphasizes judicial oversight through the Judicial Service Commission, which is designed to limit political influence and promote greater judicial independence. Going back to the question that we posed previously, it is clear that unlike the U.S. position, there is no textually demonstrable constitutional commitment of the issue of impeachment solely to any political department or institution. Drawing analogies, the fact that the American context states that the Senate sits to solely try impeachment disputes is a major departure from the 2010 Constitution. Even though the requirements for the two-thirds vote and the taking of an oath are identical, the procedure and provisions of the Constitution, as we have spelled out, leave no doubt that the Senate is not the sole determinant of the dispute. We have already expressed ourselves succinctly on the jurisdiction that has been conferred to this court under the Constitution in our previous decisions. It is now well settled that there are instances in which the courts will and should interfere with political processes. A few decisions suffice to demonstrate this position. The Court of Appeal in Martin Nyaga Wambora and three others stated as follows at paragraph 62, the political question doctrine and the concept of separation of powers cannot oust the jurisdiction of courts to interpret the Constitution or to determine the question if anything said to be done under the authority of the Constitution or law is consistent with or in contravention of the Constitution as per Article 165, sub-Article 3D2. Equally, as we have seen in the case of William Odhiambo Ramogi, the court stated that there are constitutionally permissible situations where this court may interfere in the policy decisions of the government, and particularly if a policy decision is unequal or in actual or threatened violation of the fundamental rights guaranteed under the Constitution or in violation of other provisions of the Constitution. The necessity of vindicating constitutionally secured personal liberties and fundamental freedoms is the principal justification for the anti-majoritarian power that judicial review confers upon the courts, and we are therefore reluctant to find that a claim of fundamental rights, such as the one presented by the petitioner, is non-justiciable, even though it may concern the political process or the internal workings of other government branches. Close quote. The crust of the petitioner's case centers on key questions, including whether the process was followed by the National Assembly and the Senate in the impeachment of the first petitioner, and whether the first petitioner was afforded sufficient time to prepare his defense against the impeachment charges. These issues strike at the heart of constitutional and procedural fairness, raising concerns about the extent to which legislative bodies adhered to the standards of due process as outlined in the Constitution. The petitioners contend that the impeachment process must align with the constitutional principles of fairness and justice, ensuring that any office holder facing such proceedings is provided with a reasonable opportunity to respond and defend against the charges. This court is therefore called upon to examine whether the procedural safeguards required by the Constitution were observed during the impeachment process, and whether any potential lapses could render the process flawed or unconstitutional. Such an inquiry will involve a careful review of the actions taken by the National Assembly and the Senate to determine if the principles of due process and fair administrative action were upheld. We take the view that, based on a holistic reading of the 2010 Constitution, the political question doctrine cannot oust this court's jurisdiction as granted under Article 165, Sub-Article 3. Article 165, Sub-Article 3 confers upon the High Court the authority to hear and determine questions regarding the interpretation of the Constitution and the legality of any acts or omissions by state organs. This provision underscores the High Court's critical role in ensuring constitutional compliance, even in politically charged matters. The Supreme Court of Kenya in Sonko case supports this position in its holding that impeachment proceedings are inherently political. They do not fall beyond the scope of judicial review. The court stated as follows. It's a fairly long quote. I've given it. In Martin Nyaga Wambora versus Speaker of the Senate, the Court of Appeal also held that judicial intervention in impeachment must be exercised cautiously. While conservatory orders may be issued to protect constitutional rights, they should not encroach upon the legislative process unless clear evidence of constitutional or procedural violations exists. The court underscored that judicial intervention should respect the separation of powers, ensuring that the judiciary does not undermine the functions of elected bodies. South African courts have similarly addressed the scope of judicial intervention in impeachment process, emphasizing the balance between constitutional oversight and respect for the separation of powers. A notable example is Economic Freedom Fighters versus Speaker of the National Assembly and others. This is a 2018 matter which involved impeachment proceedings against former President Jacob Zuma. In this case, the Constitutional Court affirmed that while the judiciary has the authority to ensure that impeachment proceedings comply with constitutional requirements, it must exercise restraint to avoid encroaching on the disciplinary functions of the legislature. The court made it clear that judicial intervention is warranted only when necessary to correct political procedural irregularities or constitutional violations. The ruling highlighted that conservatory orders should be applied with caution to prevent unwarranted intrusion into the legislature's domain. The court had this to say, in quote, "Courts must be careful not to impose themselves in a matter that disrupts the legislative process or undermines the authority of Parliament." Judicial oversight is essential to safeguard constitutional rights and ensure procedural fairness, but it should not extend to directing how the legislature carries out its internal disciplinary proceedings unless there is clear evidence of procedural defects or breaches of the Constitution. This decision underlines the principle that the judicial's role in impeachment matters is not to take over legislative functions, but to ensure that such processes are conducted in a manner that respects constitutional norms and procedural fairness. It reinforces the idea that while the doctrine of separation of powers is crucial, it does not preclude judicial oversight when fundamental constitutional principles are at risk. It is therefore our finding, based on the above, that the Constitution of Kenya has clearly delineated independent and distinct paths for the three arms of government. Accordingly, this court's intervention in the matter before it is warranted through a very narrow window that allows for oversight in cases where constitutional infractions are alleged in the impeachment process. This position is reinforced by our previous determination that the petitioners have established a prima facie case in the petitions before this court.
And I will hand